This is just, we're asking for a bond also.
You're whispering again.
I'm sorry, we're asking for a bond on this.
Yeah, that's what we're here for. Are you Wayne Cummings? Mr. Cummings, the best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And so this is cause number 18-29640. Mr. Cummings is on probation for the offense of manslaughter. A motion to revoke community supervision has been filed, and Mr. Kimler's filed a motion asking that I set a bond. Looks like the date of the probation was from October 22nd of 2018. A 10-year term in prison, probated for 10 years. New offense alleged in that motion is a driving while intoxicated, October 5th of 2025 in Orange, at a location other than his residence at 4:15 a.m. on October 5th in Orange, and that he was intoxicated on that date and behind in court-assessed fees. Mr. Kimler, you may proceed.
Your Honor, first observation is Mr. Cummings did turn himself in. This wasn't one where he headed for the tall grass when he found out he had an MTRP. He did turn himself in. I understand, I think this is straight probation. It's not entitled to a bond. However, with the Orange, and of course, Mr. Smith is familiar with Orange County. It may be a while before that DWI is filed, so I don't know how long it's going to take for the state to be in a position to try to prove that up. So we were just asking for a bond pending this position if they're going to proceed on the DWI. Obviously, they could proceed on the administrative violations.
Mr. Smith?
My concern, Judge, is firstly, the manslaughter was basically a DWI where he hit somebody and killed them. He had issues. Safety was a recommendation for the original probation to go through in the PSI. This new offense, the allegations apparently show he was out at 4 in the morning and was intoxicated driving. And so I would have reservations and concerns. I think there's been a relapse, and he's not actually entitled to a bond. It's a straight probation versus a deferred. So we would be opposed to a bond.
Do you know the status of the Orange County case?
I don't, Judge.
I don't think it's been filed yet, 100%. I checked before.
If it was just knowing how they work over there, if it was just alcohol, they would have already probably had the results.
Y'all are just guessing. Is there a way for us to find out? Is there any kind of hold on him?
If you want to hold it for a minute, I can call the DA's office and find out.
Yeah, let's do real quick, and we'll just do it real quick. Just have a seat, sir. And there's not. Jones. Good morning. Are you Marquise Jones?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Jones, in cause number 21-37263, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 23rd of 2022 for the offense of theft of material, and that was a state jail felony, and it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of evading arrest on June 20th, 2024 in Harris County, Texas. And is that true or not true? And then count 2 alleges that you were at a location other than your residence at approximately 1:30 a.m. June 20th of 2024. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? And did you plead true to those counts because they're actually true? Speak up, please. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
And I think I said your plea of guilty instead of true, but your pleas of true. Anyway, all right, so I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. And at this time, find you guilty of theft of material, aluminum. I guess it goes on, aluminum, bronze,
Aluminum,
copper.
bronze, copper. They were cutting catalytic converters.
And so find you guilty and sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir, and thank you for being here, sir.
Thank you.
Oh, my nose is sneezing.